A new U.S. Ninth Circuit Court of Appeals ruling finds that California Governor Gavin Newsom's COVID lockdowns of private schools are pretty flagrant breaches of the U.S. Constitution. But as with many court rulings, it's not really deserving of complete celebration. I'll lay out the details so you can remember and share them with friends and loved ones. Hi everyone, I'm Gardner Goldsmith for MRC-TV, and I think we know that the past 15 months or so have seen U.S. politicians and bureaucrats engage in some of the most flagrant, abusive theft of our rights and opportunities seen on this continent in the past century, and that some of the most damaging victims of these abuses have been kids. From birthing wards keeping newborns away from their mothers to schools forcing children to don face diapers for hours or participate in online classes, children have lost a lot. And a new U.S. Ninth Circuit Court of Appeals ruling finds that in the case of California Governor Gavin Newsom's lockdowns of private schools, the government has broken the U.S. Constitution. Writing for the American Institute for Economic Research, AIER, Ethan Yang puts this all into pretty good perspective. Quote, "This ruling was an all too rare affirmation of the seemingly forgotten fact that there is no pandemic clause in the Constitution that places the egos of politicians over the rights of individual citizens. Unfortunately, it's not quite that deserving of accolades. The case, Branch v. Newsom, was brought in 2020 by Dillon Law Group, which explains that it worked with the nonprofit Center for American Liberty on behalf of many plaintiffs to challenge Newsom's order, quote, barring in-classroom education in 32 counties and for 80% of California's children, end quote. Now, the plaintiffs asserted that by locking down both public and private schools, Newsom relegated kids to online classes. Some of them couldn't get online for sessions, and those who did often suffered through poorer quality classes compared to in-person instruction. This, they claimed, was a breach of the Sixth Amendment promise of due process of law prior to government delivering any form of punishment. The court majority agreed in a 2-to-1 decision, but this isn't necessarily something to applaud over the long term, and it's incumbent on us to understand the two reasons why. First, the court only found in favor of plaintiffs associated with private, not public schools. In the case of the public schools, plaintiffs argued that by shifting students away from in-person classes and into web-based classes, the state was depriving them of a, quote, constitutionally ensured right to education, end quote, and that they were breaching the Sixth Amendment promise of due process prior to punishment. This, Judge Daniel Collins and Judge Eugene Seiler, sitting in from the Sixth Circuit Court of Appeals, wrote, was not an affirmative call for judicial intervention because, quote, both the Supreme Court and this court have repeatedly declined to recognize a federal constitutional right to have the state affirmatively provide an education in any particular manner, and plaintiffs have not made a sufficient showing that we can or should recognize such a right in this case. Some, like yours truly, would note that the forced extraction of wealth from taxpayers is a form of punishment that stands as a breach of the Sixth Amendment due process and the Eighth Amendment prohibition against cruel and unusual punishment, since, of course, earning income is not a crime committed against another person, and since taxation provides no trial, well, then how can the state punish an innocent person by extracting his wealth for something he's not actually done to harm anyone? That's what taxation is. Instead, the Ninth Circuit majority found in favor of private school attendees and their parents, which many people are seeing as a positive. Quote, "The Supreme Court has long held that the right of parents to make decisions concerning the care, custody, and control of their children is a fundamental liberty interest protected by the Due Process Clause, and that this right includes the right of parents to be free from state interference with their choice of the educational forum itself. This right rests on Meyer v. Nebraska, 1923, and Pierce v. Society of Sisters, 1925, though it has been repeatedly reaffirmed since then." AIER's Yang offers pertinent background on those 1920s cases. Quote, "The case law they reference that extends due process protections to educational discretion are Meyer v. Nebraska, 1923, and Pierce v. Society of Sisters, 1925, which together form the Meyer-Pierce right, which is the right of parents to decide their children's education. Meyer was a case involving a teacher who violated a law mandating that only English be taught in schools by teaching German. Pierce involved a set of plaintiffs who contested Oregon's Compulsory Education Act of 1922, which mandated attendance to public school for children of certain ages. The Meyer-Pierce right would go on to be affirmed in case after case. In particular, its explicit protection of in-person schooling has been affirmed by case law as well." End quote. But that legal shorthand can cloud what should be a clear, unadulterated view of rights. There is no Meyer-Pierce right that suddenly arose from judicial precedents. There's only the eternal, reciprocal human right to be left alone, free of aggressive coercion, from theft, and of course, free from harm by others. The Meyer-Pierce so-called right is a label attached to a pre-existing human right to be left alone by the state, a right that judges repeatedly have attacked by placing wiggle room in their rulings and allowing states to interfere with free people as long as it's for a so-called compelling state interest and it's tailored narrowly, as they often say. Thus, we reach the important second flaw in what otherwise is a good ruling from the Ninth Circuit. It's a big flaw that shows us how rights constantly are under the thumb of government. Yang explains, quote, "This, the ruling, extends due process protections to private schools. That means the state could potentially close private schools. However, its policies must be narrowly tailored and not overly arbitrary. The narrowly tailored standard has been invoked by a number of judges to rule in favor of some anti-lockdown cases, although they are far and few between. In particular, an LA County judge applied the same standard to an outdoor dining ban, in which he rightfully noted that the scientific evidence as well as the state's actions do not support such a policy." End quote. The right to engage in voluntary contract and free association is not contingent on scientific evidence. It's a right, period. By placing that caveat on it, all politicians and judges and legal scholars become complicit in excusing aggression against innocent, peaceful people. Such aggression infringes on rights even if it is so-called narrowly tailored to, quote, facilitate a compelling state interest, end quote, as we often hear from legal scholars. There is no compelling state interest. There is only individual interest, only individual right. Rights are not subject to what politicians and judges say is a compelling state interest or narrow tailoring. This is axiomatic and completely irrefutable about the nature of rights. But even in finding that California infringed on the plaintiff's rights, of course, the court majority conforms to this dark 20th century legal tradition, constantly cutting in on the precept of rights. And they concluded, quote, plaintiffs presented evidence that California had failed to narrowly tailor its response, insomuch as it stubbornly adhered to an overbroad school closure order, even as evidence mounted that COVID's effects exhibit a significant age gradient, end quote. This does not comport with any semblance of the principle that parents have the right to contract with private schools for the education of their children, that they have a right to not be punished without due process, as assured by the 6th and 8th Amendments. And it also doesn't comport with the idea that they have a right to be assumed innocent of infections. It lets the state breach these rights and breach the U.S. Constitution if the state can narrowly tailor its actions for the moment, and if it can offer a strong scientific reason for attacking rights. This isn't the foundation on which a free society is based. It's a consequentialist philosophy. It embraces the same ends justify the means philosophy that saw so many horrors in the 19th and 20th century totalitarian states, like Germany, the Soviet Union, China. Some of it's still going on around the world. Careful study of this ruling indicates to us that even with a decision that appears laudable, the devil is in the legalese details, and the devil attacks individual rights. Thanks so much for watching, everybody. Hats off to those people fighting so hard to hold on to their rights and perhaps educate others about the nature of individual rights and this legalese that constantly attacks. Hey, if you have the opportunity and you're watching on YouTube, please do us a favor, like and subscribe and share the videos if you can. Do the same if you're over at Rumble as well, because Rumble is a great new site and they're not very censorious at all. So we like that a lot. Visit us at Facebook. Visit us, of course, at MRCTV.org, TikTok, and you can find the whole gang on Twitter. For MRC TV, I'm Gardner Goldsmith.